if he really was granted this special use permit, it would result in the bizarre situation of his house being labeled a house of worship, which is not what he was seeking to do. He doesn't think of his house as a house of worship. He thinks of it as a home, a private residence, where he should just be able to invite people over for communal prayer like you would invite people over to watch a football game or something of that nature, in which case you don't have to request a special use permit for your home.
Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Alexa Kawlewski, a recent graduate of Notre Dame Law School.
Thank you for joining us for this episode of the Napa Legal Podcast. I warn you that I have this nasty combination of a cold and some allergies, so if I have to mute myself and start coughing, I apologize in advance, but we're going to try to power through. So before we start, as always, we appreciate it if you like the content we're putting out. It helps to support the work we're doing. If you like the podcast, subscribe to our channel on YouTube or Spotify or whatever platform you're listening from. And with that, we'll dive into this week's issues. So some interesting cases and a new law that we wanted to cover. First, we'll go to the Eighth Circuit. There's a case that's now up on appeal regarding a COVID vaccine mandate and a religious exemption or lack of religious exemption in this case. Then we'll go to an appeal that was recently made to the Supreme Court on behalf of an Orthodox Jew who was forced to obtain a permit to pray in his own home. Alexa's going to lead that one. I'm very curious to hear how that works. And then we're going to conclude with a recently enacted law in Tennessee, Tennessee joins a number of other states that are passing laws to protect single-sex spaces for women. So with that, let's go to the first case. In the Eighth Circuit, this is a really fascinating one, and I think it's of interest to me because I worked on this like pro bono on the ground during COVID. I remember when these mandates started coming down. So does everybody who is listening to this podcast, because if you live in America, you probably dealt with this. The vaccine mandates were broad, but it really depended on what place of employment you were dealing with, how ideologically committed they were to the vaccine mandate, also how strapped for employees they were. Some people were very generous in just giving bona fide religious exemptions. Some places, like the city of St. Louis and their school district, apparently not so much. So this controversy arose when St. Louis required all teachers to receive the vaccine for COVID in order to teach in the classroom. On paper, there was availability for both medical and religious accommodations. Several teachers who are involved in this lawsuit sought religious accommodations to the school district's policy. They were denied. The city claimed that teachers could, again, seek accommodations for either religious or medical purposes, but it looks like the record shows that everyone who applied for a bona fide medical exemption got it, and everyone who applied for a religious exemption was denied. So don't know how case by case and in good faith they were really treating these. Doesn't look good. So this case went to federal district court. It was a civil suit. A jury actually awarded the teachers like $4 million in damages for what they went through. But the school district appealed. So now this case is in the Eighth Circuit. And it came to our attention because our friends at the Beckett Fund recently filed an amicus brief just last week in the Eighth Circuit, urging the court to recognize this is a pretty clear violation of the teachers' rights and is asking them to uphold the verdict from the district court. So this case is called Brandon versus Board of Education of the City of St. Louis. And Beckett, I think, makes a pretty compelling and straightforward case that this is obvious discrimination against religious requests. Every single one of them was denied. I want to point out a couple of interesting factual issues that play in here, and then I'll talk a little bit about the legal scenario. So first, the teachers here who have serious religious beliefs, especially this was common early on. Like I said, I worked on these. The first, I think it was 3 vaccines that were all approved when these mandates started coming out were all tainted by aborted fetal cell lines somewhere in the research or development. So if you have a religious objection with taking vaccines that are tainted with aborted fetal cells, these were bona fide objections. So every teacher who made these exemption requests, they were either placed on unpaid leave or they were terminated for requesting an accommodation that the school said that they offered, right? Religious exemptions were offered on paper. And it's particularly crazy to me that St. Louis did not have just a surplus of teachers and they could handle this. Like St. Louis School District apparently faces a teacher shortage, and there was a lot of very practical effect on student learning. The students suffered a lot of loss to access to a lot of programs. I know, Alexa, you did some research on this. So there were a lot of things that were suspended or removed, an elementary school theater group, the aviation program, these dual credit programs for world history. They just weren't able to do these because they didn't have enough teachers. So it's particularly unfortunate not only that these teachers' rights were violated, but the kids suffered because they don't have enough teachers. So legally, I want to talk for a minute about the challenge of free exercise clause challenges to these laws. It's been tricky since Employment Division versus Smith. I'm pretty sure at this point, every listener to our podcast knows what that did. It's a 1990 case that said that if a law is neutral and generally applicable, even if it does in fact burden religious exercise, it doesn't get strict scrutiny under the First Amendment. But we've been carving a lot of exceptions out to Smith since 1990. The court has been pretty consistent in what we're hoping is the eventual death by 1,000 cuts to the Smith precedent. But so in this case, there's precedent here. The court has said in the Roman Catholic Diocese of Brooklyn, that was a 2020 case, and then Tandon v. Newsom was the big one in 2021. The quote from the Brooklyn versus Cuomo case: government regulations are not neutral and generally applicable, and therefore they do trigger strict scrutiny under the free exercise clause whenever they treat any comparable secular activity more favorably than religious exercise. So, of course, here we're not talking about secular activity the same way. It's not like religious worship versus opening a restaurant, but there is an analogous problem here, right? That like there's a secular exemption, medical, and you're giving them, but there's a religious exemption that you're not giving. You're treating the secular exemption more favorably than the religious exemption. I think that's pretty clear. That's a problem. And not only is it a problem to burden on religious exercise, but it renders that law not generally applicable. There are exceptions. So it's by definition not generally applicable. The way I read it, I think that's fairly obvious. Beckett pointed out in their brief that there's an interesting circuit split on this issue as to whether medical exemptions to a vaccine mandate do in fact render the law not generally applicable. There are several states that have, or several circuits rather, that have held that the medical exemption actually does not hurt the argument that it's still a generally applicable law, which I'll get to that in a second. But so the defenders of that view say that, well, medical exemptions are consistent with the purpose of the vaccine mandate, which is to uphold public health, right? We uphold public health by having a vaccine mandate. We also uphold public health by not making people take a vaccine if they have a medical reason not to do so. It sounds convincing, but I think it's tricky. Like it's clever reasoning. But I think the other argument is right. If the compelling government interest is properly articulated, you can make something broad enough where you can make it say anything. Like our compelling interest is public health. But no, in this case, it's not. It's more specific. Your compelling government interest is to vaccinate a sufficient number of a population to protect public health from that particular disease. Like that's what you're doing. You can say you have a compelling government interest to uphold public health and use it to justify almost anything. You have to be a little more specific what the government interest is. And in different circumstances, the court has been insistent on that before. So in this case, and Beckett argues this in their brief, and it's at least, I think there are two circuits, the first and I believe the 10th, who have said something like this. If the government's interest is to vaccinate the population against a disease, the medical exemption, even if it's necessary, it does undermine the compelling interest. It undermines the goal, the same way a religious exemption would, right? If your goal is to vaccinate as many people as possible, giving exemptions for medical reasons is vaccinating fewer people. It's in conflict with the government interest. That's just true. So I have a problem with making the compelling interest so broad that you can justify anything. But it's, I think, a clever way to avoid the fact that this is clearly not a generally applicable law. If there are exemptions, you're undermining your interest, and you can't then treat the secular exemption more favorably than the religious one. I think that's right. Once you acknowledge that point, that these are both undermining the government interest the same way, then we're back in the territory of these same line of cases like Tandon v. Newsom, that if you're treating the secular purpose or activity more favorably than the religious one, then we have a First Amendment problem, and strict scrutiny is warranted. And the other thing I'll say legally is the Beckett brief also points out based on the Groff versus DeJoy case. If you don't remember, that's the postal worker who wouldn't work on Sundays that went up to the Supreme Court a couple terms ago. The Groff case, the court held that the government must show that accommodation of an exemption, a religious exemption in that case, would impose an undue hardship on the employer. And the court says in Groff, to establish undue hardship, the district must show that the burden of granting an accommodation would result in substantial increased costs in relation to the conduct of its particular business. Of course, circumstances are a little different, but the point is it can't be just a de minimis burden. That was established pretty clearly in Groff. Like, if this is burdening the employer, it has to be pretty substantial. So putting aside the general efficacy of this vaccine at preventing the spread of COVID, there's just not really an undue hardship in granting a few religious exemptions to teachers when every medical exemption requested was already granted. So I would say, like, absent of showing that the number of teachers seeking religious exemption was like so exorbitant that, you know, you'd have a majority of your teachers unvaccinated, again, questions about whether that would actually matter. I'll leave that there. I don't see the undue hardship to the school district in accommodating these requests. I just don't. So Beckett's brief summarizes this issue nicely. Under Groff, the court has said that religious believers can't be required to choose between their faith and their job. And that's what these teachers were forced to do in St. Louis. So they already had a jury verdict. I'm hoping that they're successful in the Eighth Circuit. And it's a good case. It's fascinating. I just interviewed my friend Nathan Lloyd from the Thomas More Society a couple weeks ago about vaccine mandates in the military. It's still like kind of astounding to remember that we're still litigating COVID vaccine mandate cases, because a lot of them are like 4 and 5 years old at this point. So God bless them for continuing to fight the fight here.
Yeah, and I would add that for the issue of general applicability, you can have this both in the text of a policy and in the facts of a specific case. So the school district could have had a policy that said everyone has to have the vaccine unless you request it for a bona fide medical reason, and then potentially we'll grant you an exemption. And that could be all that they said. And then you would have the same question of religious discrimination or undue hardship on a religious group or individual because of the lack of an exemption written into the policy for them. But then you can have it on the flip side of what we actually see in this case, where it's stated in the policy that they should have access to a religious exemption or accommodation. But then in practice, it appears that it was never granted to a single individual. And even if you did grant it to some individuals and not all of them, you could still have an interesting factual question of whether the accommodation is really present, and therefore whether it's actually generally applicable to all, and proper in that way. And so you can have it on both ends. And while we only see the one end in this case, there are a lot of COVID cases where you see the both.
No, that's a good point. You're right. And I personally dealt with both cases where it was one of the most fascinating. I remember talking to an extremely large corporation that I obviously will not name, talking to their general counsel's office. And they basically said, we're just not going to look at religious exemptions. We're not granting them, which is that's blatantly unconstitutional if they're granting secular medical accommodations. But they had a huge legal department. They didn't want to grant them. And they were playing a game of chicken that they figured they would win. It's disturbing in both ways, when it's on paper discriminatory and when it's in fact discriminatory. But I think this is a pretty good case. So we will keep an eye on what the Eighth Circuit does with this one. And from there, let's move into this cert petition that's pending before the Supreme Court. This one's fascinating.
Yeah, this is as interesting as the facts are of our COVID case. This, I think, gets even more interesting with the facts. We turn to Ohio, University Heights, Ohio, specifically, where Daniel Grand, who's an Orthodox Jew, lives in a neighborhood, in a private residence, in an area that is designated from zoning laws as just a residential space. So zoning laws typically will designate different uses like residential and commercial and various things like that. And residential typically means a single family home or multifamily home and a group of those in a particular area. And that's what his home is zoned for, or was at least, or seems to still be, in University Heights, Ohio. And he wanted to invite about a dozen people to his home to pray a minyan on the Sabbath. And this is just a threshold requirement for one of the most sacred acts of Jewish communal worship. So it's a communal prayer. It has to be done in this community of sorts, but it doesn't have to be done in the synagogue. So he can do it at his home. And he had invited these people via email just to come over in 2021. But before it took place, University Heights city officials found out about this plan and immediately required that he cease and desist any and all use of his home for communal prayer, unless he first obtained a special use permit. So a special use permit is another area of zoning law, which would grant an individual plot of land that is zoned for, let's say, residential in this case, to be used for something other than what the typical zoning law indicates for it, because they're essentially being granted an exception to the zoning law. So you'd have to apply to the city for the permit and then be granted the permit for this special use. And what they wanted him to do was request a special use permit to use his home as a house of worship. So not even to just have a sort of exemption from the general residential zoning law, but to actually change the zoning of his particular property to a space of house of worship, which obviously, and I think interestingly, raises an odd question that Alliance Defending Freedom, who's working on this case along with Oric, Harrington, and Sutcliffe, has noted, which is that if he changes his home to a house of worship, it's no longer a private residence, and raises interesting questions about whether his family and him can actually live there, because that's not the indication in the zoning law of what you can do at a house of worship. It's not a space of residence. So they're asking him to do something a bit bizarre to begin with. But Grand was attempting to work with the city on this. So he originally did apply for the permit and was attempting to receive the permit, but the city didn't really stop there. So before the hearing on the permit took place, police were asked or were ordered to watch his home to make sure that he didn't host any of these gatherings, any of these minyans, and neighbors were told to file complaints if any gatherings occurred. So what you really have here is it looks like a group of people in the community who are just not excited about his use of his space in the way that he would like for religious reasons. He had property violations issued against his residents. He was denied access or some sort of part of his certificate of occupancy for his home, and some of his tax abatements were withheld. So he had additional tax money on his home, even going so far as to not collect his trash at his residence sometimes. So it really seems like the city went beyond just simply requesting a permit for a special use and took steps further into an area that may be called harassment against him for this request that he was making. And the reply brief in this case filed by ADF, like I mentioned, the case name is Grand versus City of University Heights, explained his numerous attempts to comply. So he initially files, he submits the permit application, neighbors submit opposition to his request. So they submit a letter to the city. One of the things that was in this letter was a statement that they, quote, did not want our neighborhood labeled as Jewish, end quote. So clearly a lot of animus against Grand and his family specifically, and the Jewish community there in general. And that seems to be most likely present at the city level as well, considering the number of actions that they've taken against him. And that the public hearing that followed his permit application displayed a lot of hostility to Jewish practices and to him in the community in general. And the city commission at the closure of that hearing simply asked him to submit additional materials, which is not an uncommon thing to see from a city commission who doesn't really want to grant a special use permit or a variance or a change in the zoning law, is they will always ask someone to just do more. So they asked him for more materials to be presented at a second hearing. It was at this point that Mr. Grand withdrew his permit application, partially because he did not want to subject himself and the members of his family to a second hearing because the first one was so hostile, and partially because he realized that if he really was granted this special use permit, it would result in the bizarre situation of his house being labeled a house of worship, which is not what he was seeking to do. He doesn't think of his house as a house of worship. He thinks of it as a home, a private residence, where he should just be able to invite people over for communal prayer, like you would invite people over to watch a football game or something of that nature, in which case you don't have to request a special use permit for your home. The district court dismissed his religious discrimination case. Potentially, they didn't dismiss other parts of the case if there were multiple things at issue here, but the religious discrimination part, I know for sure, was dismissed by the district court, and the appellate court upheld that dismissal. So now the case has been appealed to SCOTUS, the Supreme Court, with the hope to make it clear that this is in fact a religious discrimination issue and that it's an improper labeling of a house as a house of worship.
Yeah, I have so many questions about this case. Admittedly, this is not something I've ever really thought of because the only time I've seen issues like this where police were patrolling and like preventing gatherings at a home for religious worship. There was one in California, but it was related to COVID regulations about gatherings over 10 people or whatever. But in the absence of like a state of emergency order, which is there's still religious problems, obviously, but without that, this just seems like completely insane to me. I mean, there is a First Amendment besides the free exercise issues. There is a right to freedom of assembly, which I know a lot of the precedent on that is related to the ability to assemble in public places peaceably. But I think there's precedent applying that to in private residences as long as the owner of the residence is in favor. And like you said, I mean, you can invite that many people over for a football game. Or for a party or for dinner. So this seems to be clearly now in the problematic realm of what we were talking about in the last case with issues like Tandon v. Newsom. It's like you're pretty obviously treating secular activities more favorably because I'm sure the police are not going around telling people that if you have a dinner party for 12 people, you need to get a restaurant permit. Like, that's not how like use of a home works. So this is kind of crazy. I don't have too much else to say on this other than I'm surprised that it's gone this far. This seems like a wild use of zoning law to police what goes on inside a house. But the other question too is I'm a little bit confused about how they're using house of worship as a weapon rather than a protection, right? Because houses of worship usually apply for that status because of the benefits. Like houses of worship are generally tax exempt from state property taxes. Like, is Ohio going to can he make part of his home a rectory where he lives with his family as the minister? And then part of it is because again, and rectories or like houses for clergy are generally exempt from property tax as well. So if that's where we go, if he gets this zoned as a house of worship, does he get his property taxes taken away? I doubt it. So this seems like a very confused jumble, and it's a road that I'm surprised the government would this aggressively go down. I'll be very curious to see whether SCOTUS takes it. I on one hand, I know SCOTUS is very picky about what they take, but this seems to be really egregious. So I wouldn't be too shocked if they actually do grant cert in this case. We'll clearly be keeping an eye on this one.
It's also interesting to remember that most zoning laws are happening at the municipal level. So a lot of what we're talking about typically is a state level. Even if you have a city actor, like the City of St. Louis School District is acting, and it is in that case, the City of St. Louis school policy, but those tend to be like uniform across the state, or at least you're seeing major cities employing the same kinds of policies. Most of what we're seeing is state action, even if not directly done by a state actor. But these cases, zoning cases, are almost always municipalities. So you see cities or counties drawing up these laws. And sometimes you just get confusing and bizarre zoning laws or zoning results. Like the city commission might have clear zoning laws laid out, but then bizarre requests like submit a special use permit when maybe that's actually not the appropriate course of action under the zoning law for an individual to take. Um, and that could lead to SCOTUS being less interested in the case, even though it hasn't had a positive result at either the district or appellate level, just because it's more like a simple confusion and less like a nitty-gritty legal issue. But you do have potentially interesting legal questions if you see a lot of zoning laws across a lot of municipalities in various states that don't really have a mechanism for dealing with like what you might call special use cases if there was a legitimate reason to have a special use request. So this, you have 12 people coming over to pray, probably not a legitimate reason to have a special use request. But if somebody said, I actually want to build a chapel attached to my house, or I want to convert part of, my extra bedroom into a space that priests can stay in, or something of that sort, where you would actually see legitimate zoning laws coming into play for a residential, at least, area, then it might be more interesting about like, would a variance apply? Would a special use permit apply? How would this be dealt with by a county or a city?
Yeah, that's a great point. I hadn't thought of this, but I haven't read too deeply into the briefs or the appellate court case. Do you know, are these all straight First Amendment cases? Is there a RLUIPA claim in here as well?
I don't know. Potentially there is, since he withdrew the permit application. That
Mhm.
might make the legal question more difficult because he didn't have an application pending when it
Yeah.
was denied. And that could be part of the reason the religious discrimination part was thrown out. But there could be a secondary claim made on that too.
Yeah, I'd be interested to see a case like this go up on RLUIPA grounds because usually RLUIPA involves like a religious organization trying to develop land and getting rejected by a zoning board. But something like this, it would still apply because RLUIPA doesn't require a religious organization. It's just religious land use
Mhm.
being substantially burdened by a municipal land use law. So that this is a fascinating and really wild fact pattern. All right, let's finish in Tennessee. This one is a little less complicated and a sign of hope as far as I'm concerned. So, the governor of Tennessee on May 22nd signed a bill that protects the safety and privacy of women and girls in various spaces that are designated single sex, right? Public restrooms, prisons or jails, domestic violence shelters, dorms, things like that. So, the bill is quite clear that biological women cannot be subject to harassment, assault, violence by having biological males who identify as female coming into these shared spaces. So these these spaces are in place for some obvious reasons. I want to get into that in a second. So, but first, the law itself, it defines male and female for purposes of these spaces by biological attributes, removes gender identity and other subjective terms from the state's definition of sex. And further, any state governmental agency in Tennessee is basically prohibited from interfering in this by prohibiting these distinctions based on biological sex. So it's important for I think an obvious reason. This doesn't need too much commentary, but I'll say first it's good to see Tennessee, who has already done important work on some of these issues, right? Most of our listeners will probably remember that Tennessee was the one who spearheaded the issue of banning the mutilation of children under these crazy transgender procedures, and that resulted in the Scrimeti case in the Supreme Court, where it was held that indeed states can ban these gender mutilation surgeries and procedures on minors. So now Tennessee is added to the list of states enshrining this kind of common sense into law. They're not the first state that's done it. We've covered this before, but it's good to see when these trends spread. Just want to make a couple of quick points. For one, this doesn't have anything to do with ideology, right? It's pretty clear that when biological boys or men are allowed into intimate spaces like beds and locker rooms and bathrooms with biological girls or women, creates a very real danger, not just of discomfort, but of sexual abuse. So this is a real thing. Nobody's saying that every single time a biological male goes into a bathroom, there's a sexual assault, but it's not an abstraction. It's not a fantasy. We've seen stories of rapes and assaults on girls by biological boys in bathrooms and locker rooms. some of which have been covered up, presumably to protect the ideology from criticism. These things really happen. There was that case in which county was it in Virginia? There's a school district. Was it? I don't know if it was Loudoun County. I can't remember, so I won't say for sure. But there was a case where there was biological male in female bathrooms sexually assaulting girls, and it was pretty clearly being covered up by the school district. These things happen. They're preventable, and that's why these spaces have always been single sex, right? And then that goes into my other point that allowing people into these spaces based on their so-called gender identity rather than their sex, it effectively just ends single sex spaces. There's really no way around this, right? There's no way to police or enforce locker room or bathroom requirements that are based on gender identity because you're basing it on a subjective inner thought or feeling, not an objective or outward reality, right? So these policies of allowing people to use whatever restroom or changing room or what have you that they identify with, it has no practical outer limit, right? They're not limiting it to people who have undergone these mutilating actual transition surgeries, right? If a man dresses like a woman, says he's a woman, that also seems to pass muster, and now he can be in the ladies' room. So where does it stop? If a man doesn't dress any differently, if a bearded, big, muscular guy just says, I identify deeply as a woman, is he also allowed in the women's restroom or changing room based on his identity, his gender identity? I don't know where you can draw the line. Once subjective feeling of what your identity is the defining characteristic, then pretty much anyone can use whatever changing room or bathroom he feels like. There's no longer any meaningful distinction that you can enforce. So I think most people realize that these single sex spaces are necessary for privacy and comfort and also physical safety. And there's no way to make those common sense rules coherent unless it's based on actual sex. So, and I try not to say, by the way, we're picky with words here. I don't even like biological sex as a term because that implies that there's some kind of sex difference other than biological, and there's not. It's just sex. Like there are men and women, there are boys and girls, and anything else is subjective feeling and not real. So, again, I'm grateful to see Tennessee basically just enact common sense into law here, both to protect women and also to preserve the reality that single sex spaces based on actual sex rather than subjective feeling are necessary for a lot of reasons.
Yeah, absolutely. Completely agree. And also, even though the bill is specific to a group of kinds of places like prisons, dorms at public universities, things of that sort, if it's not specified and you have just like a general allowance to create these spaces, you could see everything from the grocery store to the movie theater to anywhere, just completely removing the distinctions from bathrooms, which also has a lot of practical implications for people just trying to live in the world, even if you're someone who maybe has less of a difficulty with it. Like, oh, maybe I would be okay with other people doing it, but like, I just don't want to see it everywhere. Even then, like you would just see it take over a lot of the public spaces that all people are trying to use. So it's good to see that we are starting to cabin where that's appropriate and where it's not appropriate. And also nice that I think you're not seeing a large trend for corporations or places like grocery stores to just create like, single-use bathrooms. That seems to be a typical quote unquote solution to this is people will just say, well, okay, we'll just do single occupancy restrooms and we'll call them restrooms for anyone. But I don't think that that's really established itself as the trend of where we're going. You see some places do this, but it's not the typical action. So I think it's a sign that we're moving in the right direction.
Yeah, I mean, personally, I'm on a comfort and safety level. Like, if you really want to do that, fine. If you want to do a bunch of single occupancy bathrooms or locker rooms, whatever, that doesn't obviously make me uncomfortable. In a lot of ways, it's more comfortable, even in single sex spaces. A lot of people would just rather not change in front of other people. But it's expensive, right? Like this is, if that's your ideological preference to not have these sex segregated spaces and you want to spend the money as a company to do that, fine. But it certainly shouldn't be mandated. There's a reason we've always had these single sex spaces. It's obvious. Yeah. All right. Well, with that, I think we'll wrap up here. So thank you all for joining us, and we hope you'll join again next week as we continue to highlight and discuss the most important ongoing legal issues that affect religious freedom and particularly the work of faith-based nonprofit organizations. We'll talk to you next week. Thank you for joining us, and God bless you all.